Now, estate planning is not just about what happens after you die. It also includes incapacity planning. Take, for example, this scenario. You've got two children, ages 3 and 6. It's your anniversary, and you decide you want to go celebrate your anniversary with your spouse, and you're going to go to a Kenny Chesney concert. Why? Because Kenny Chesney is a national treasure. You're left your children with young Susie. She was age 14. She's not your first pick for babysitter, but she does a pretty good job anyways, and she'll be fine. You find yourself driving to the concert when suddenly the car stops and you feel your soul's being lifted out of your body. Aliens abduct you. They leave a note that says, "We'll return the souls in 3 months." What happens? Well, technically, being abducted, having your souls abducted by aliens would probably account as being incapacitated. We're just going to say it does. The big question is, what happens to your children? My name is Gregory Singleton. I'm an estate planning attorney. We are here to talk estate planning. As part of our essential series today, we are going to be looking at the power of attorney to appoint a temporary guardian or custodian of minor children, also known as, my term, the Guardianship Directive. Now, a Guardianship Directive is technically it's called the Designation of Standby Custodian or Standby or Temporary Custodian under Minnesota Statute, Chapter 257B. I just call it a Guardianship Directive for short. Now, what it does is it authorizes someone to step in the shoes of a parent while the parent is alive and incapacitated. Now, notably, this is not just when one is alive and incapacitated, it's one of the parents is alive and incapacitated, and the other one is deceased, unavailable, maybe they're in prison, incapacitated, has their parental rights terminated, or is otherwise incapable of providing child care for their minor children. A minor means, of course, children that are under the age of 18. Now, interestingly, most estate planners don't prepare a guardianship directive as part of the estate plan. I think that is a big mistake. The thinking is that if one of the parents is incapacitated, then, grandma or sister or brother will just step in and take care of the kids until the parent regains capacity. The challenge is if the child needs to have something happen with the schools, or goes to the hospitals, or gets in trouble with the law perhaps, or has some other government agency interaction, then you're going to need to have someone with actual parental authority to be able to sign off on things. And if you don't, then the courts and social services will have to get involved, and that costs money and that costs time, and those are things that we don't want to have to do. Very simply, a guardianship directive, they're inexpensive, easy to draft, and they fill an important hole in the estate planning. Now, do beware, there are two types of guardianship directives. One is a durable power of attorney for guardianship. What we've been talking about. This is a standby guardianship directive. It is a springing power of attorney that comes into effect when one parent is incapacitated and the other is either somehow unavailable or incapacitated. Now, there's also a temporary guardianship directive. Now, this is a durable power of attorney for a planned excursion, for example. Let's say a single parent needs to, let's say you're a scientist and need to go to Germany for research for 3 months and leave their kids with grandma. Well, to make sure that if the kids have to deal with the hospitals or to do with the courts or with some other government agency giving grandma authority, you put in place a temporary guardianship directive. Now, this is not the standby. It is not effective upon incapacity. It is effective upon a certain event, and it is ineffective at the end of expiration date. A standby guardianship directive is ineffective when you recover capacity or all parents have deceased. There's one thing I do want to touch on, and that is the difference between a temporary guardianship and a permanent appointment of guardian under a will. In the temporary guardianship directive is what we're talking about here. They're effective until the parents all die or are incapacitated or recover incapacity. You can use them to designate a permanent guardian, but generally we don't. Generally, we designate a permanent guardian when all parents are deceased. We designate that in the will. Or if you have a revocable living trust, you're going to designate it in your pour-over will. There are different goals when doing a temporary guardianship versus doing a permanent guardianship. For example, with a temporary guardianship, we are looking to maintain normalcy in the child's life. We want them close to their friends and family and support group, be able to keep going to school and probably visit mom and dad in the hospital until aliens return the soul to the body in 3 months' time. Under a permanent guardianship designation under a will or pour-over will, we are looking to raise the child to the age of majority. Now we're looking at things like parental philosophy. What will set the child up best in life? Will they be raised in the appropriate religious beliefs that you think they should be? What is the real financial ability for that, for the designated guardian, the permanent guardian, to actually raise those kids to the age of majority? Grandma, for example, who's 92, might be great to take care of the kids for a week or two or whatever it may be until the kids recover, until the parents recover capacity. But giving a 3-year-old to, let's say, a 92-year-old grandmother to raise to the age of majority, well, that's just not really realistic. So you can and probably should, in many cases, have different temporary guardians than your permanent guardian designations. Guardianship directives are a vital part of your estate plan if you have or are planning to have minor children. Unfortunately, they are often forgotten about, even though they fill an important gap in the estate planning strategy. I hope you liked today's video. If you did like today's video, please feel free to hit that like and subscribe button. We do videos every other Wednesday. If you have comments, leave them in the questions, leave them in the comments below, or send me an email. Otherwise, until next time, this is Gregory Singleton with Signature Law.